By the time the clerk called the final case, the courtroom had already started to feel like a room running on fumes. The long benches were half empty, the fluorescent lights seemed harsher than they had that morning, and even the people still waiting had that worn-out look that settles over a place where too many small disasters have passed through in a single day. I had seen arguments over broken fences, overdue rent, dented bumpers, barking dogs, and the 1,000 other ways ordinary lives collide when money is short and patience runs thinner than it should. On paper, the file in front of me looked no different. It was a minor dispute, the sort of case most people forget before they reach the parking lot. A few typed pages, a modest claim. Nothing in the paperwork suggested this one would leave a mark. But the moment the old man rose, the air in the room changed in a way no file could ever predict. He was 84 years old, the bailiff had mentioned before the hearing began, and he moved with the cautious precision of someone who had learned to negotiate pain without announcing it. His suit was old, pressed, and just a little too large for the thin frame age had carved out of him. His hands trembled slightly as he adjusted himself at the table, but his chin remained level. There was no self-pity in him, no performance, no attempt to win sympathy before a single word had been spoken. He simply stood there carrying something heavier than the paper folder placed in front of him. I looked at his face and saw the kind of wear that doesn't come from one hard year or even 10. It was the wear of decades, the deep-set eyes, the careful breathing, the expression of a man who had spent a lifetime learning how to keep private burdens private. Yet there was something else there too, something harder to name. Not fear exactly, not confusion. It was closer to urgency, as if whatever had brought him into my courtroom mattered to him in a way no one else in that room yet understood. The opposing side sat straighter than he did, younger, better dressed, visibly irritated by the inconvenience of being there. Their posture fit the paperwork. His did not. I asked the old man to state his name for the record. He cleared his throat, placed one weathered hand on the table to steady himself, and answered in a voice that was softer than I expected, but steadier than it had any right to be. The room leaned in at once. That happens sometimes when truth enters quietly instead of dramatically. People feel it before they understand it. I glanced back down at the file, then up at him again. The case still looked ordinary. The man in front of me did not, and after years on the bench, I had learned that when those two things refuse to match, the paperwork is usually the least important part of the story. Once his name was entered into the record, I asked the kind of opening question I ask in 100 cases a month. I expected a narrow answer, something limited to dates, documents, and the immediate dispute. Instead, the old veteran answered with a patience that made every ordinary question feel as if it were brushing against something much larger. He did not ramble. He did not dramatize. He simply spoke the way some men do after a long life of carrying difficult things alone, choosing each word carefully because they have learned that wasted words cost energy they no longer have. He had served in the military when he was barely more than a boy, he told me, and the habit of standing straight had stayed with him long after the uniform stopped fitting across his shoulders. Even now, with age working against his back and his legs, some old instinct in him kept trying to meet the world with discipline. He mentioned the war without flourish, almost reluctantly, as if service were a fact and not a credential. But facts have weight when they are worn quietly. He had crossed oceans, buried friends, and returned home to build a life that was never as stable as people assume it will be for men who have already given everything once. As I questioned him, the details of his present life emerged in fragments. He lived alone now. His wife had been gone for years. A son he once depended on had moved across the country and called less often than he should. Most mornings began before sunrise, not because he wanted them to, but because sleep had become shallow and unreliable. He made his own coffee with hands that sometimes shook, checked the mailbox even on days when he knew there would be nothing waiting, and kept a house that had grown too quiet for a man who had once lived among noise, orders, engines, and the rough brotherhood of people who understood him without explanation. He apologized once for taking time, and that apology told me as much as anything else. Men who believe their pain is an inconvenience usually did not learn that lesson from weakness. They learned it from being overlooked too many times. Even before the heart of the case surfaced, that habit of minimizing himself said plenty. The courtroom listened more closely with each answer. What had looked like a routine complaint began to feel like something else entirely. The man before me was not fighting over a small issue because he was petty. He was there because, at this late point in his life, the matter in front of the court had become tangled with something much deeper: pride, memory, and the desperate human need not to be discarded while still breathing. I asked him why he had come in person instead of letting someone else handle it. His eyes lowered for a moment, and when he looked back up, there was no anger in them, only fatigue and a dignity so plain it made the room still. He said that when you get to his age, people begin speaking around you instead of to you. They summarize your life in forms, signatures, and convenient explanations. They tell you what can no longer be fixed. They suggest what is no longer worth fighting for. And after a while, if you are not careful, you begin to disappear even before you are gone. That was the moment sympathy turned into attachment. The file no longer described the case. The man did. And somewhere beneath his calm answers, I could already sense that he had not come merely to win a dispute. He had come because something sacred in his past was being mishandled in the present, and he needed one person in authority to see the difference. I asked him to explain in his own words what made this case so important. For the first time since he had taken the stand, he did not answer immediately. He rested both hands on the table, looked down at the worn brim of his hat, and seemed to gather not facts, but courage. When he finally spoke, the courtroom heard the difference at once. This was no longer a man responding to questions. This was a man opening a door he had kept shut for most of his life. He told us that during the war, he had been part of a small unit sent into a stretch of fighting so chaotic that the map stopped mattering after the first hour. Shells had torn through the night, orders had broken apart, and boys who had barely learned to shave were suddenly expected to decide who lived long enough to see morning. In that confusion, one of his closest friends, a young soldier named Thomas Avery, had been hit. Not killed instantly, he said. Worse than that, alive long enough to know what was happening, long enough to be afraid, and long enough to ask for one final promise. The old veteran's voice thinned, but it never broke. He said Thomas had pressed a bloodied hand against his sleeve and made him swear that if only one of them got home, his mother would not hear some polished version of her son's death from a stranger in a pressed uniform. She would hear from someone who had been there, someone who could tell her that her son had not died forgotten, not died alone, and not died as a line on a government page. He had promised. At 19 years old, in smoke and panic and terror, he had promised. Then he lowered his eyes and told the court he had failed, not because he had forgotten, not because he had stopped caring. He failed because he came home carrying more ghosts than a young man knew how to bear. He failed because the war ended, but the sounds did not. He failed because years became decades, and each year made the promise feel heavier, not lighter. He found Thomas's mother once, he said. He even drove to her town. But he sat outside her house with both hands locked on the steering wheel and could not force himself to walk to the door. What words could he bring her that would not reopen everything? What right had he to arrive so late? He drove away, and then he kept driving away for the next 60 years. Now, the reason for the case stood exposed. The dispute before the court involved a box of military effects, letters, and personal belongings that had surfaced after a property transfer and were being treated as little more than misplaced objects. To the other side, they were old items with uncertain value. To him, they were Thomas Avery's last remaining pieces of a life cut short. Inside that box was a letter meant for the mother who had long since died, and now for the surviving family who never knew this witness still existed. His hands shook harder as he said the words that finally brought the room to silence. "I'm 84 years old," he said, "and I do not know how many mornings I have left. But I could not leave this world having broken that promise." There are moments when a courtroom stops being a place of arguments and becomes a place of truth. This was one of them. What had looked from the bench like a stale dispute over ownership had become something else entirely, a final act of loyalty, delayed by trauma, shame, and time. The law could identify who possessed the box. The law could sort through transfer, notice, and procedure. But none of those things touched the center of what sat before us. This old man had not come to win property. He had come to keep faith with the dead before he joined them. In one breath, he had turned paperwork into memory, procedure into conscience, and a forgotten case into sacred business. I looked around the room and saw faces that had changed along with mine. Even the people who had entered out of boredom now sat motionless, as if any unnecessary sound would be a form of disrespect. And as I turned back toward him, I understood that whatever happened next could no longer be ordinary. For a few seconds after he finished, no one moved. The courtroom, so often full of interruptions, objections, and impatient sighs, had gone completely still. I looked toward the opposing party and saw the confidence drain from their posture. A moment earlier, they had treated the matter like a technical disagreement over possession, paperwork, and convenience. Now the shallowness of that position stood exposed in the open. They had arrived prepared to argue ownership. They had not arrived prepared to answer what it means to stand in the path of a dying man trying to keep a promise he had carried longer than some people carry their own names. I asked their counsel whether anyone on their side had taken the time to understand what those effects actually were before reducing them to a disputed box on an inventory list. The answer came wrapped in procedure, which is often how people hide from humanity when humanity makes them uncomfortable. There had been notices, they said. There had been forms. There had been deadlines. It was, according to their reading, a closed matter, a closed matter. I repeated the phrase because sometimes the only way to reveal the poverty of an argument is to let it hear itself aloud. There sat an 84-year-old veteran who had crossed the length of his own life to finish one act of unfinished duty, and the best the system could offer him was that the matter had already been closed. The law matters, procedure matters, deadlines matter. Courts cannot function if every case dissolves into sentiment, but law without perspective becomes cruelty wearing a respectable jacket, and procedure without judgment becomes a machine for overlooking the very people justice is supposed to protect. The law is meant to organize human conflict, not erase human meaning. I turned back to the veteran and asked one final question. If the box were returned to him, what would he do with it? He answered without hesitation. He said he would find the surviving family, if any remained, and place every letter, photograph, and belonging into their hands himself. Then he would tell them what he should have told their mother decades ago, that Thomas Avery was brave, that he was loved, and that in his last moments he was not abandoned by the men beside him. There was no self-defense in the answer, no attempt to impress the room, only purpose. That was the moment my own composure began to fracture, not because judges are supposed to feel nothing, but because some truths arrive with such clean force that resisting them would be a kind of dishonesty. I ruled that the veteran was to receive immediate possession of the military effects, and that any claim standing in the way of their release failed both morally and legally under the circumstances presented. But the ruling alone was not the real correction. The real correction was saying, in a room where he had risked being reduced to a nuisance, that what he had done by coming forward mattered. I told him that time had not erased the promise. Delay had not emptied it of value. Shame had not made him faithless. If anything, the fact that he had carried it this long proved the depth of the bond he had tried, in his imperfect human way, to honor. You did not come here too late, I said. You came here while you still could." His mouth tightened, and he nodded once, as if even gratitude required too much strength. Around us, the courtroom had changed. The old hierarchy of winner and loser no longer seemed important. What mattered was that, for once, the institution had not hidden behind distance. In that silence, even clerks and spectators seemed to understand that dignity had just been returned to a man history nearly forgot. It had listened, and because it had listened, a burden carried through war, silence, and old age had finally begun to lift. I thought the ruling would be the end of it. In most courtrooms, that is where the story stops. The order is given, the file is closed, and everyone returns to their separate lives carrying whatever version of justice the day has handed them. But this old veteran did not sit down. He remained standing, one hand resting lightly on the table, the other reaching into the inside pocket of his coat with slow, deliberate care. For a brief second, the whole room watched him with that fragile kind of silence reserved for moments no one wants to disturb. Then he drew out a folded photograph, worn soft at the edges from years of being handled. He asked if he could approach the bench. I nodded. When he placed the photograph in front of me, I saw a young soldier smiling into the camera, all sharp cheekbones and impossible youth, the face of a person who had not yet learned how quickly life can close its fist. On the back, in faded ink, were a few words barely surviving the years. "Tell my mother I wasn't afraid." The old man looked at the picture, not at me, when he spoke again. He said he had carried that photograph through marriages, funerals, hospital visits, birthdays, layoffs, sleepless nights, and every quiet morning that followed him into old age. There were years, he admitted, when he thought the burden would outlive him. Years when shame convinced him he had no right to fulfill the promise anymore. Years when he believed silence had hardened into something permanent. But he had kept the picture because letting it go would have meant accepting that Thomas Avery's last request no longer mattered, and he could never bring himself to commit that second betrayal. His voice faded, then steadied once more. He said he did not come to court asking for pity. He came because he wanted, before his own name was spoken only in the past tense, to leave this world having done one thing right. That was when the tears came. Not loudly, not theatrically, just enough to remind everyone in the room that even people trained to measure facts can still be reached by truth. I took off my glasses and let the silence hold for a moment, because there was nothing useful to say over the weight of what had already been said. Then I told him that some promises are kept not by speed, but by endurance. Some acts of loyalty take a lifetime to complete, and some men, despite all the years they spend believing they failed, discover in the end that faithfulness was there all along, living inside the refusal to forget. He closed his hand around the photograph and nodded. It was not the nod of a man who had won a case. It was the nod of a man who had finally laid something down. As he turned to leave, the room rose almost instinctively. No one had been instructed to stand. They simply did. For one brief, unplanned moment, age was not frailty, grief was not weakness, and justice was not a line in a ruling. It was remembrance. It was dignity. It was a tired old soldier walking out of a courtroom a little lighter than he had entered. Long after the file was closed, that image stayed with me. Not because the law had done something extraordinary, but because on that day it had done something rare. It had made room for the full measure of a human life. And sometimes, when people ask what justice looks like at its best, I think of an 84-year-old veteran, a faded photograph, and a promise that finally reached home.